is there any other evidence that you wish to present to this court as it relates to Rule 59?
I will, Your Honor.
Okay, go right ahead.
Okay. My name is Andrew Grodner. I'm a pro se litigant in the divorce case in Pitt County, number 13 CVD 398. Grodner v. Grodner. I am an economics professor at East Carolina University since 2004. I married the plaintiff, Ms. Summerlin, in June 2010, and our son was born in August 2011. I have been served with a complaint for divorce and custody in February 2013 by her attorney, Jeffrey Miller, who has been representing her ever since. Recently, I have received numerous direct email messages from Mr. Miller where he knowingly and willfully lied about preparation and filing of 8 January 2019 order to recuse Judge Brady. I have personal knowledge about those emails because I was one of the recipients of those emails. I also know that the following statements by Mr. Miller in those emails are false because I'm aware of evidence directly contradicting his statements. Mr. Miller lied in his email on January 9, 2019 at 11:38 when he wrote, "As I have indicated to you," meaning Ms. Harzog, "I do not intend to submit any bullet point suggested findings." And let be Exhibit 1 of my statement, and this is a copy for...
Judge, I'm familiar with that email.
Right.
Okay. Mr. Miller lied in his email on January 9, 2019 at 12:57 p.m. when he wrote, "My only contact with Judge Teague about an order has been in the course of the hearing of this matter." This would be Exhibit 2. I think Mr. Miller is familiar with this one as well. Yeah, go ahead. Oh, I'm sorry. So, this is Exhibit 2. Okay, no. Okay.
Judge, can I ask which one is Exhibit 2?
9th January 2019 and 12:57 p.m. Mr. Miller lied in his email.
Excuse me, Judge. I just have 3 copies that have a heading indicating regarding January 7, 2019 period, and they all are January 9, 2019 dated. Is there another one?
Can I see what you've got? This is saying January 9th, 2019 at 11:38.
I'm trying to understand what Exhibit 1 and Exhibit 2 are.
Exhibit 1 is email from January 9, 2019 at 11:38.
Well, the one that I have, January, what day?
Yes, Your Honor.
What date is it?
January 9th, 2019.
At what time?
Exhibit 1 is 11:38, and the false
Excuse
statement
me.
is highlighted.
Excuse me.
Yes, Your Honor.
Okay. You may proceed.
Thank you, Your Honor.
Was there an Exhibit 2, Judge? I know that you said Exhibit 2.
I have something here. It has Wednesday, January 9, 12:57 p.m.
Yes, Your Honor.
Public
This is
records request for any and all communications of Mr. Miller and Ms. Davis with Pitt County Courthouse officials regarding Judge Brady recusal order.
I just have it. Thank you.
Mr. Miller lied twice in his email on January 23rd, 2019 at 3:59 p.m. when he wrote, "As everyone also knows," and here I believe he referred to Ms. Davis, Ms. Harzog, and whoever was in the courthouse, "I ultimately declined the invitation," meaning invitation to provide findings of fact. And just on the side, I believe that Ms. Davis, as herself, potentially can testify to some of those statements because she was recipient of those emails, and she was present at that hearing, and Mr. Miller in that email actually spoke about it. He also lied in the same email by saying, "I told," there is an underline in his email, "Megan..."
Excuse me.
Yes.
Which?
This is Exhibit 3. I'm so sorry about this. So let me be systematic about it. This is January 23rd, 2019 at 3:59 p.m. And this is from Mr. Miller. Okay.
Now, which one, is this Exhibit 3?
That is Exhibit 3, Your Honor. Yes, that is correct. And the second statement that was false...
Excuse me,
yes.
sir, hold on. Okay, you may proceed.
Thank you, Your Honor. So, Mr. Miller, in that email from January 23rd, 2019 at 9:59 p.m., the second false statement was, I told Megan I was not going to submit anything in reference to proposed findings of fact related to the January 8, 2019 order. Mr. Miller lied in his email on January 24th, 2019 at 11:38 a.m. when he wrote, I orally told Megan I was not going to submit anything. This is going to be Exhibit 4. Again, this is January 24th, 2019 at 11:38 a.m. Mr. Miller lied in his email on January 31st, 2019.
Excuse me, sir.
Yes, Your Honor.
Are you now referring to this document?
Yes, Your Honor.
So this is Exhibit 4.
Yes, Your Honor.
You may proceed.
Thank you. Mr. Miller lied in his email on January 31st.
Excuse me, sir.
Yes, Your Honor.
Simply state what you are talking about.
Regarding Exhibit 4 that Your Honor has in hand, I believe, there's an highlighted text in the first line of the email where Mr. Miller says, I orally told Megan I would not be submitting anything, and my statement is that was a false statement by Mr. Miller. It is a highlighted part of the email at the very top, at the very beginning, at the very top. Yes, Your Honor, when you read the beginning of the email, this is email from Mr. Miller, where he begins by saying, I didn't stream anything, and then he follows up, I orally told Megan I would not be submitting anything. That part is a false statement by Mr. Miller.
Go ahead.
Thank you, Your Honor. Mr. Miller lied in his email on January 31st, 2019 at 4:21 p.m. when he wrote, I do not know if or how anything was communicated to Judge Teague where Mr. Miller meant regarding the 8 January 2019 order. This is going to be Exhibit 5. So this is January 31st at 4:21 p.m. And let me be very clear. I highlighted the false statements. This is again Mr. Miller's email to me, and others. You can see other people on it. In fact, including Ms. Davis. So he actually lied to Ms. Davis, and it's line 1, 2, 3, 4, and 5. I'm waiting for Your Honor to give me go.
You may proceed.
Thank you, Your Honor. And lastly, Mr. Miller lied in his email on February 1st, 2019 at 2:14 p.m. when he wrote 3 statements. Judge Teague did not receive a message from me. I did not have an ex parte contact with Judge Teague. I have not lied about anything, and that's going to be Exhibit 6. And throughout the whole email, all of this is highlighted.
You may proceed.
That's it.
Judge, I don't know what he believes Ms. Hartzog would lend to this case. And the problem with the matter that I think is becoming more and more apparent to the court is none of this has to do with the case. all of this has to do with his position and perceptions about me personally and as a lawyer. And as the hearing goes on, we'll get more flavor of that, I'm sure. But you've seen essentially what his position is. He wants to call me a liar. He wants to say I'm a liar. He wants to present documents, including a document in which I say I have not lied. That's his evidence. I told him I had not lied. And beyond that, he wants to quibble about whether there is an oral statement to Ms. Hartzog or a written statement to Ms. Hartzog, but nothing really about the case. And as I've said to Your Honor, there's no value that Ms. Hartzog would lend to the case because essentially he's not entitled to any motion that he's filed as a matter of law. It is clearly on its face a frivolous action and matter. And I would say that's another reason not to drag Ms. Hartzog into the middle, but she has counsel and they can decide that issue. I'm here to stand by everything that I've said in emails, everything I've said to anybody about the case, everything I've said to Mr. Grodner in any way. But I don't think that there is any value in bringing Judge Brady into the case by a subpoena initially. He didn't even show up for the date that he subpoenaed them, and then over the weekend when nobody would know, he issues one of his emails that he withdraws the subpoenas. So we all show up that morning. He doesn't even come. He does go to the clerk's office and file his withdrawal that very morning, but he doesn't even come into the courtroom where the people that he subpoenaed, where we're having the hearing that he caused. He doesn't even come here. And we engage in that kind of business, in his case, at his whim, when he does these things. And Ms. Hartzog is the latest victim of his activities and conduct. I'm still here willing to respond to any of the claims that he has made with regard to the matter, openly, candidly, with no problems. But I don't, unless he can give some foreshadowing of what he believes his evidence with Ms. Hartzog is going to yield to this court on a Rule 59 motion that is without authority. And Judge, as I said, I provided the cases he has, and Davis v. Rizzo says it very clearly and concisely. And the second case, Tetra Tech Tesoro, says it clearly and concisely. And that one is even in the context of a summary judgment kind of motion. So he really, I want him to say what he wants to say about me, and I want him to have all the time he wants to do that. And whatever the court wants to indulge with that is fine with me. I'm here to do that. But all the collateral damage that he is doing by his conduct, I hope we will address in the other motions that I have filed, and that there is no basis for Ms. Hartzog to have to endure this.
In my motion, one of the statements I made was that Mr. Miller, false statements resulted in Judge Brady's removal, that he continues to willfully knowingly lie to the court officials. I have earlier on provided evidence of the emails that were willfully and knowingly sent to me, Ms. Davis, and everybody in the courthouse. I subpoenaed Ms. Hartzog because she is, first of all, Mr. Miller is obviously the recipient of, sender of those emails, so that's why he was subpoenaed. But also Ms. Hartzog was subpoenaed because she's a public official. I do have public records request emails where Mr. Miller did receive an email from Ms. Harzak where she actually, let me tell you this.
Do you have copies for council? to
Yes,
look at
yes, I do,
further?
Your Honor. Yes, I do, Your Honor. Let me see. Okay, so that's going to be Exhibit 6.
Hold on just a moment, give them an opportunity to review it.
Yes, Your Honor. Yes.
Judge, I already have an Exhibit 6.
Exhibit 7, I am very sorry. Yes.
Hold on. Let council review it first.
Yes.
Any objection?
I'm sorry, Your Honor, objection to it being
Exhibit.
entered into evidence?
Yes.
Oh, no objection, Your Honor, thank
All
you.
right, so you'll hand it to.
So,
copy
Chris?
copy to the bailiff.
So on January 8th, 2019 at 9:44 a.m., Ms. Harzak, without informing me, sent email to Mr. Miller and Ms. Worthington stating, Judge Teague does not need your written facts. He got a copy of the CD. Do you want to take a look at the order before it is filed and mailed out? Then my public records request also revealed an email that Ms. Harzak sent to Judge Teague, where she says, email from Jeff, or, so let me just proceed one at a time. That's going to be exhibit, to the Constitution. And council can review this if they'd like to.
Any objection?
Object.
No, Your Honor.
Right, sir.
Thank you. So there's another email from Ms. Harzog to Judge Teague. I understand this is the official email address from Judge Teague, where he has on nccourse.org. And she says, email from Jeff on Grodner. And this is forwarded below. There is a forwarded email messages, which says Jeff Miller, mail to jeff@miller@audino.com. This is from, and then it says to megan.l.harzog@nc.org, nccourts.org. I do not have that original email. I have to admit, public records requests that I've made twice have revealed that it doesn't exist. It is my contention that Ms. Harzog, as part of my public records request to her, she did delete it intentionally to conceal that information.
You have any
Because
evidence to support that?
I don't. This is why I wanted to ask her. This is exactly why I wanted to have her testify. Because there is an email that I know exists, and she was the only one that could have deleted this. But basically in that email...
Can you substantiate that claim, sir?
I can only
I'm
say...
just asking you, can you substantiate that claim?
I can substantiate it by the fact that I've made 2 public records requests.
No, my question is, simply because you made the request does not substantiate the claim that Ms. Harzog deleted it. Those are serious allegations.
Yes, Your Honor.
I don't know her. I don't know anything about her. I wouldn't know if she walked in the courtroom right now.
Yes, Your Honor.
But those are just serious allegations. That's why I asked you if you had any evidence, not statements, but evidence.
The evidence is that when I asked her for public records request, Ms. Harzog did not send me those emails, meaning that she was deceitful to me the moment she
No,
was
sir, that's not
responsible.
what you said. Your statement was that she deleted the email. That's why I was asking you, do you have any evidence to substantiate your claim?
Your Honor, my statement was my contention is I don't have a proof that she did that.
Okay. Go ahead.
So, given that that email has been received by Ms. Harzog, it says, no, this is from Mr. Miller to Ms. Harzog, no, if he does not need me to prepare a proposed order and does not need me to submit any proposed findings, and I would copy Grodner even though he defaulted and did not appear, then I think the best thing to do is simply send it to us in the normal course. Thanks, Megan.
All right. Now, as it relates, was there a request for interrogatories?
There was a request for interrogatories.
And was there a motion to quash that request?
There is, Your Honor.
All right. Now, the motion to quash the interrogatories is allowed pursuant to Rule 26, Rule 1A, Rule 26. Now, as relates to your request for a new trial, or your request for a continuance, rather, what does Ms. Harzog have to do with your request for a continuance? Or is this in conjunction with your request?
All right, let me go back and say, in my request for continuance, I said that Mr. Miller continues to willfully and knowingly lie to court officials, and the court accepts Mr. Miller lies as the truth. Mr. Miller, just today, told you he stands by every single email that he sent, that I recited, that he did not have any communication with Ms. Harzog. This is your proof that he was lying to you right now. And it is my understanding that Your Honor is willing to believe his lies and proceed with this hearing, even though...
Listen, where'd you get that perception?
This is my contention that...
Well, it sounds like that's your contention of the whole system, sir.
No.
Then why did you say that? Because you have no basis for making that statement at all. I'm simply asking you questions, and if you don't answer them according to what the law requires, that doesn't imply anything. I'm just asking you to provide to this court what is sufficient in your case. That's all I'm asking. I don't know anybody here. I don't have a dog in this fight. I know nobody. I don't know any of these attorneys. They just introduced themselves along with you. I don't know these people. So I'm here to make a decision based on what the facts are, what the law is. I don't do any preferential treatment.
So, okay.
So that's an assumption that you have taken that's not accurate. And I just wanted the record to reflect that. Go ahead, sir.
So I like to state that I have proven beyond any doubt that Mr. Miller has lied in the emails that he sent me to Ms. Davis and Ms. Harzog. Ms. Harzog also has been dishonest to me, and my position is she didn't do it, I believe, to deceive me. I believe that she has done it upon urging from Mr. Miller, because some of these emails that he sent immediately, he almost suggested what Ms. Harzog is supposed to do. He was writing that he told her, kind of implying that maybe she should not tell her to me that she had any emails. And in fact, later on, when she responded to my public records request, she did not provide me those emails. I have made this public records request, and those emails showed up, and Ms. Harzog has not provided it. That's why I wanted to ask her to testify, to basically be a witness and an evidence of Mr. Miller lying.
Well,
May I be heard briefly? Your Honor, public records requests need to be made through AOC, through Jonathan Harris, our general counsel. It is impossible to delete an email. AOC is always going to have retained those emails. And so if those records, public records requests are made of AOC, AOC will comply with the law.
Mr. Grodman,
Yes, Your Honor.
in response to counsel's statement.
Yes, perfect. I mean, it's a wonderful segue. So,
Excuse me,
yes.
that didn't answer the court's question, sir. Counsel indicated that if you'd like to get public records from any state agency, that you would contact the Office of the Administrative Courts.
I did, yes, Your Honor. And this is the proof. This is, we can put it as Exhibit 9. On January 12, 2019 at 7:07 a.m., I have made such requests. And if you could pass it.
The point is, it is improper to send these requests to individuals throughout the court system. They need to go through our general counsel, John Harris.
Okay. Let me,
Judge, I know that I received an email, and I thought it was from Ms. Davis, that told him how to make a public records request as well when he started down this road.
Now, hold on, Mr. Grodman. Sir,
yes.
I know this may sound harsh, but I'm not here for a fishing expedition. I'm here to hear some motions. Your motion to continue is that you think Mr. Miller is being false to the court and that he shouldn't be involved in the case.
Yes, Your Honor.
Well, other than what you've alleged that Ms. Hartsdog would say, and if she would say that she's given you these emails, what bearing has that got to on the issues of this case?
Well, one is obvious, Your Honor, and Mr. Miller lied to Your Honor just a few minutes ago. And Your Honor did not stop him, didn't say, please, Mr. Miller, tell the truth. And Your Honor didn't try to verify whether he was telling the truth.
Excuse me, I'm not here to try a case, sir. That's not my job. I'm not here to assist in a case. I only asked for clarification.
Yes.
So, whatever assumptions you want to make, that's on you, but the record is clear. I'm not here for preference. I'm not here to assist. I'm trying to get to the bottom of this